Serial number 40.
There is no case in this board which does not have a date.
DT.30.04.2026 of 2026.
Yes, madam, you are there? This case you are there? Yes.
When the charge was registered under section 103, 238 and 3 clause 5 of BMS, which was reduced to section 108 of BMS. And Lordship, my humble submission is that the petitioner has never been engaged in any kind of conflict with the deceased person. Rather, the deceased was unhappy because she was thrown out of her father's house, due to which she has to live in her matrimonial house. And there is no
From where do you say that she was thrown out of her father's house?
It is given in the case title.
She was found dead in her matrimonial house.
Yes.
She committed suicide. You are the husband.
No, Lordship. She was not.
Who are you?
I am the husband. I am the
She was not happy with her parents.
yes.
But she should have been happy with her husband, isn't it?
Because there was no amenities in her matrimonial house. Therefore, she used to always go to her maternal house. And when she was thrown out from her father's house, so she was not happy coming back to her maternal house. And she was never used to.
She died within how many days of marriage?
She came on
Marriage.
2017, the marriage was organized. So, 8 years.
8 years. But from where do you say that marriage was solemnized in 2017?
No, this was given in the case time by the statements.
Read the FIR first. पढ़ी
एक लिखित आवेदन दे रहा हूँ कि दिनांक 25/9/2025 को सुबह 9:30 बजे मेरी बेटी आरती देवी किसी दूसरे के मोबाइल से फोन करके बोली कि मेरा पति आज मारपीट किया है। मैं अपनी बेटी को बोला कि आऊँगा और सिखा समझा देंगे। यह बोलकर मैं अपने ड्यूटी चला गया। इसके बाद इसी दिन लगभग 2 बजे दिन मेरा दामाद संतोष हेमरम फोन किया कि आपकी बेटी आरती देवी मर गई है। यह सुनकर मैं ड्यूटी से अपने घर लौटा और घर के व्यक्ति और गांव के कुछ लोगों को लेकर गोदरा गांव नौगाटाड़ पहुंचा। यहाँ आकर हम लोगों ने देखा कि मेरी बेटी आरती देवी मृत लेटी हुई थी। दोनों पैर, गर्दन, पीठ, छाती, कुर्ती एवं गला में चोट का निशान देखे। देखने से ऐसा लग रहा था कि मृतक के साथ हत्या करके पुनः
So immediately before the incident, as per the FIR, she died of her fall.
During the time of incident, no one was there at the house.
That's right.
And it was after the incident that occurred that everyone came along with the husband to rescue him.
State, what do you have to say?
Yes, my lord. Witnesses have told that before the occurrence, she called to their parents and told that her husband has beaten her. That's from para 6, 7.
For the learned counsel appealing on behalf of the parties, the learned counsel for the petitioner has submitted that the petitioner has been wrongly made an accused in the case, though he is the husband of the victim. And the victim was found dead in matrimonial house. She submits that the parents of the victim had in fact thrown out their daughter, and she was not happy in the matrimonial home because of such incidents. The learned counsel for the state has opposed a prayer for bail and has submitted that, as per the FIR, immediately prior to the incident, the doctor had rung up the informant father that the husband has been assaulting her on that day. And the independent witnesses have also supported the case that the victim had called her father and informed her father about the assault by her husband. Considering the aforesaid facts and circumstances, this court is not inclined to enlarge the petition on bail is rejected.
Serial number 41, BA 2841 of 2026.
There is recovery of three mobiles, two SIM cards, custody since 2021.
How many mobile?
3 mobiles, 2 SIM cards, custody since 22/1/2026. Not, and there is no antecedent. And not, during investigation, it has come that there is online complaint of 3 victims has been pointed out, but the statement of only one victim of 18,000 has been examined. Statement has been recorded, charge sheet has been submitted. The other 2 victims' statement has not been recorded, neither there is any complaint. Only online portal complaints.
How much is the amount?
Yes, the for 18,000, and the second is of the victim examined of 18,000, and there are other 2 amounts, online complaint of 9,500 and 3 lakhs rupees. But they were not examined.
Any FIR instituted pursuant to that
no,
complaint?
no. होता क्या है, जो NCRP पोर्टल पर जब कंप्लेंट होता है, बैंक ब्लॉक होता है, पैसा वापस चला जाता है, तो उसमें FIR नहीं होता। बहुत बार ऐसा जो है उसमें सिर्फ कंप्लेंट होता है, that they complaint, they acknowledge as one complaint. There is no FIR, there is no details, charge sheet has been submitted.
Yes, go to
3 complaint and of 3
एक ही victim का statement record
तीन अलग अलग विक्टिम का कंप्लेन है। एक का 18,000 एकड़, 9,500 एकड़, 3,25,000। Out of 3, 1 victim had been examined in the investigation, Lord Judge, who has stated that he has been cheated 18,000 through the mobile SIM received.
1/8.
Yes.
1/8. Any antecedent other than
No.
this? For the learned counsel's opinion on behalf of the parties, the learned counsel for the petitioner submits that 3 mobile and 2 SIMs have been alleged to be recovered from the petitioner, and the petitioner is in custody since 21/2026, having no criminal antecedent. He submits that as per the during investigation, 3 online complaints of victims has been found, but statement of only 1 victim has been recorded. The charge sheet has already been submitted. The learned counsel for the state has opposed a prayer. However, the aforesaid submissions made by the petitioner is not in dispute. It is further not in dispute that no separate FIR, no other case has been instituted against the petitioner. Considering the fact that charge sheet has been submitted and there is no other criminal case against the petitioner, the petitioner is directed to be enlarged.
Serial number 42, BA 2854 of 2026.
डायरी हमें प्रोवाइड करेगा।
ये इसका डायरी मांगे, इस पर्टिकुलर केस का।
इसी का एक दो किताब 2 केस के पास
ठीक, बस 2 केस कल रखना, पोस्टमार्टम एट द रिक्वेस्ट ऑफ द काउंसिल फॉर द पिटिशनर पोस्टमार्टम। ये डायरी आप उनको वापस कर दें।
तुरंत करके नोट
Serial number 43, BA 2861 of 2026 with serial number 44 and 45.
What has been recovered? How many phones?
1 mobile phone.
one mobile and
one SIM card,
one SIM,
two cards, ATM cards, and 15,000 cash. Yes. There is no criminal activity, Your Worship. And the petition is in custody from 21 January 2026 and charge sheet has been submitted.
how many victims?
No victim, no victims.
स्कीम बना के
एक ही साथ में नो बैक आउट ऑफ फाइल है नो
Attached cases.
PA number 2861 of 2026. Heard by the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that one mobile, one SIM and two ATM are alleged to have been recovered from the possession of the petitioner with cash of rupees 15,000. However, no victim has been identified. He submits that petitioner has no criminal antecedent. He is in custody since 21/1/26. 29/1/26 and charge sheet has already been submitted. The learned counsel for the state has opposed the prayer but does not dispute the aforesaid submissions made by the learned counsel for the petitioner. Considering the fact that petitioner has no criminal antecedent and charge sheet has already been submitted, the petition is directed to be enlarged.
Serial 44 BA 3167 of 2026.
ये मोबाइल है, सिम है और
One mobile, one SIM and
टू सिम
two SIM and
एक ATM कार्ड है और 30,000 कैश है.
antecedent.
नहीं, it is there in the order sheet.
And
Incident नहीं लगा है.
charge sheet,
चार्ज का सेम ही केस है.
same case है.
जी.
आप बताइए क्या बोलते हैं?
इसमें काउंटर फाइल किया एनेक्सर में सर
Annexure A में क्या लिखा है?
एनेक्सर मेमो ऑफ एविडेंस है. इस मेमो ऑफ एविडेंस में डिस्क्राइब जो है प्लॉट में उसको
ये
और इसमें
बोल रहे हैं तो-
चार सीट सबमिट
ये बोल रहे हैं तो ठीक ही बोल रहे हैं ना? The learned counsel for the petitioner submits that the petitioner is in custody since
29
29/1/26, having no criminal antecedent, one mobile, two SIM and one ATM with cash of rupees 30,000 is alleged to have been recovered from the possession of the petitioner. The petitioner has no criminal antecedent. Charge sheet has already been submitted. The learned counsel for the state has opposed the prayer for bail. However, he does not dispute the aforesaid submissions. Considering the submissions, and the fact that the petitioner has no criminal antecedent and charge sheet has been submitted, the petitioner is directed to be enlarged.
BA 3308 of 2026.
no incident, no victim.
One mobile, same case है, same case है, custody same है. One mobile, one SIM, no victim has been identified. उसमें भी कोई victim नहीं
नहीं
identified.
यही चीज आया है सब में.
No victim has been identified. Charge sheet submitted.
One case is assumed 3.6, therefore diary may be written from 6.
Have we just moved? ठीक है, इसका bail कर दीजिए. At this counsel for the petitioner has submitted that the bail of co-accused
BA number 3500.
is fixed on
6
6 during BA number
3500
during BA number 3500 of
26.
26. Office is directed to place the case diary in BA number 3500 of
6.6.
ठीक है, अपने
Yes.
ये उसमें डाल दीजिए.
Serial number 46 BA 2862 of 2026.
The FIR is section 137 to 87 and 64 of BA, section 6 and 4 of POCSO. There's
Read
an
the
allegation.
FIR.
Yes, FIR is at page number. Starts from page number 11. Prosecution case is at page number 13.
Please do not take the name and read.
Yes. निवेदन पूर्वक
Age of victim बताइए.
Yeah, as per the FIR, it is 16 years. And there is an allegation that हम 18/1/26 को शाम 6 बजे घर से निकली. जब हम लोग खोजबीन किए तो कुछ पता नहीं चला. तो रमनाथ थाना आकर गुमशुदगी का आवेदन दिया था. आज दिनांक 20/1/26 को थाना के सहयोग से मेरी पुत्री की बरामदगी की गई. जब मैं अपनी लड़की से बात किया तो कि तुम कहाँ गई थी, तो उसके द्वारा बताया गया कि कमलेश सो पहला फुसलाकर शादी का झांसा लेकर ले जाया गया था. 2 दिन तक गढ़वा में रखकर शारीरिक संबंध बनाया था. मेरी पुत्री के साथ ये भी बताया गया कि पुत्री के द्वारा ये भी बताया गया कि पूर्व में लगभग 1 वर्ष से मेरे साथ शारीरिक संबंध बनाया है. मेरी पुत्री द्वारा पूछताछ करने पर बताई जब घर पर कोई नहीं रहता था तो मेरे साथ जबरदस्ती शारीरिक संबंध बनाता था. ये सब के चलते मेरी पुत्री के द्वारा नहीं बताया. As per the statement of the informant, there was a physical relationship with the petitioner for long 1 year, but no FIR, no complaint has ever been lost. And also on the last time, case diary's statement, the statement of the victim and medical report was also called for. The counter affidavit has been filed by the state, and it has been shown that as per the medical report, there is no injury on the body, no sign of physical recent sexual intercourse. And the charge sheet has already been submitted and there is no criminal antecedent of the petition.
183 का statement.
On that case diary भी मंगाया गया उससे. She has stated that there was a love affair between them.
She has not stated about any love.
No, she has stated.
183 में statement नहीं.
हाँ 183 का ही.
पढ़ी?
Recorded at section 183.
अच्छा ये.
एकदम लास्ट लाइन में है हमारे बीच प्रेम संबंध.
When the alleged offence had taken place, she was 15 years of age.
As per the that one एक साल पहले से था she was, but there is no as of now there must be the age proof of the victim, but the state has to say whether what document the prosecution has produced with regard to
Age का victim का क्या age है? What is the age of the victim as per medical examination report?
इसको तो साइन कर दिया ऑब्वियसली. एक 2010 की.
हाँ?
एक 2010.
1/1/2010. Date of incident कब का है?
date of incident is कोई डेट नहीं है, बस बोलते हैं कि 1 साल.
FIR का डेट बताइए.
FIR का डेट है 20th January 21 2026.
21?
21 26. See. But no complaint, no FIR was lodged by the victim at any point of time.
Bail नहीं दे सकते.
So when the statement of the victim is concerned, it appears that she was having love affair.
She has said that it was forceful. She has been denying she wanted to study. She said that she will have a relationship only after marriage. इतना कहानी वो बोली है अपनी स्टेट. एज में भी बहुत फर्क है, कोई मैचिंग एज नहीं। आपका 24 इयर्स, काफ़ी 10 साल का फर्क है, 9-10 साल का फर्क है, एक क्लास में पढ़ने वाले स्टूडेंट नहीं। Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that there was love affair between the party and the victim was having love affair for last 1 year prior to the FIR. FIR was lodged on 21/2026. He has submitted that the petitioner is in custody since
20th January 2026.
21/2026. FIR decision was also in custody.
On the same date, the victim was recovered.
The charge sheet has been submitted. Counsel for the state has opposed the prayer and has submitted that the petitioner, as per the bail application itself, is 24 years of age, and the date of birth of the victim is 1/1/2010. And as per the FIR, there was forceful sexual intercourse. She was taken away from the lawful guardianship of her parents. After hearing the learned counsel for the parties and after going through the statement of the victim recorded under section 183 PMSS, wherein she has alleged that the petitioner forcefully established physical relationship with her in spite of the fact that she was insisting that she would study, and the forceful relationship could be established only after marriage. This court is not inclined to enlarge the petitioner on bail.
Serial 47 BA 2864 of 2026.
The FIR has been lodged under section 126 to 64, 76, 351 of BNS and 4/8 of POCSO. As per the FIR, the age of the victim is 60 years, and no doubt there is a direct allegation against the petitioner. Only one prayer. So charge has been framed in the month of March. No witness has been examined. So only that observation to expedite the trial.
इस पे भी आपका एक्सपीडिशन स्ट्राइक दिल्ली कर सकते
हाँ.
स्टेट कहाँ है स्टेट कहीं चले गए थे
नहीं है बैठे.
इस केस में भी एक्सपीडिशन स्ट्राइक के लिए बोल देते हैं, आप विटनेसेस प्रोड्यूस कर दीजिए. However, the state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director prosecutor. आपके ऑर्डर में बोला है. इसमें बताइए चार्ज कब फ्रेम हुआ?
इसमें चार्ज नहीं हुआ. चार्ज हुआ है 10 मार्च 2026, 10/3/2026.
Trial has commenced.
No, there is no prosecution witnesses have been examined. The case is on the
For
examination
production of
the-
witnesses.
Yes.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and the age of the victim as alleged is 16 years. However, benefit of 2 years be given to the petitioner. यही बोलेंगे ना?
नहीं, इसमें तो डायरेक्ट
इसमें तो वो भी
इसमें बोल सकते थे, लेकिन इसमें तो
he has submitted that he would be satisfied if the trial is expedited. The charge has been framed on 10/3/26 and no witness has been examined so far. And there are only 5 witnesses. And as per that should be so. The learned counsel for the state has opposed the prayer and submits that there is direct allegation against the petitioner. However, he submits that there is no impediment in production of witnesses. After hearing the learned counsel for the parties and considering direct allegation against the petitioner supported by the statement of the victim recorded under section 183 PNSS, which has been placed on record, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the witnesses are promptly produced. The counsel for the state is directed to communicate this order to the Director of Prosecution and SP of the concerned district.
Serial number 48, BA 2919 of 2026.
Yes.
Now, the case of the prosecution is that the wife of the informant happens to be the maid in the Manrega scheme.
Sorry, 5 of the informants.
Maid.
Need क्या?
Maid होते हैं frontline supervisor. Petitioner happens to be the panchayat seva.
Need in Manrega.
Manrega scheme. My lord, there is an allegation.
Petitioner is the supervisor.
Panchayat seva.
Yes.
Now he is in custody since 27/12/2023.
27/12/25. Charge print.
No charge. The only allegation, my lord, which has come in the FIR, that my lord, there was demand of ₹5,000 for passing the bill of the wife of the informant. This was the allegation. Thereafter, after my lord, the verifying officer has alleged that there was demand of ₹15,000.
Corporate and
Contract and my lord, but tendered money is now, of course, my lord, 15,000. While the demand was as per the allegation, demand was only 5,000. Now, my lord, we kindly appreciate that the petitioner does not want to pay the payment of wife of the informant since he is not the maid or the labor in the department.
she is not the neighbor.
She is there. He is not. He is the husband and informant. Now he went to the petitioner and demanded the money of payment of his wife. That has been declined. भाई आप अपनी वाइफ को भेजिए, वाइफ आएगी उनको हम दे देंगे. Now the my lord we can appreciate, and my lord I am inviting your lordship attention, page 60, which is the in complaint of the informant. What was the period? The period is only for the period of 14/12 से 20/25. Page 16. Very short FIR. 5,000 रुपये का डिमांड करते थे. मैं रिश्वत देकर काम नहीं कराना चाहता हूँ. March 14/12/25 से 20/12/25. Now, my lord, it is the document annexed with the FIR from page 18, 19, 20, 18, 19, 20. My lord, may appreciate that ऊपर नीचे में देखा है. Signature is there of wife of the informant. In each bill, she made her signature, and thereafter payment has been made to the maid. Petitioner has nothing to do, no business with the Manrega scheme, and he had gone to demand the payment of his wife. That was declined. कि भाई आपको हम दे देंगे, कल के डेट में आपको बोलेंगे किसको आप दे दिए, मेरा पेमेंट दीजिए. So entire allegation appears to be suspicious. And what
That
was
के समय कौन पैसा दे रहा? Who was making payment at the time?
ये informant? Husband.
Husband of complainant.
Husband of complainant was making payment for release of payment to his wife.
The application report given the ACB matter, the Tama unit now. His wife,
My lord, page 16 is there. Page 16 is there.
ACB को कंप्लेंट किसने लॉन्च की?
Taramuni.
वाइफ है ना?
Yes.
तो उसके बाद हस्बैंड कैसे पैसा लेके चले?
वो जाते थे उस नोनी को बुलाया कि
बहुत अच्छा, हस्बैंड एंड वाइफ एक हो जाएंगे क्या?
और इसमें उनके लिए जो बोल एलिगेशन है प्रत्येक बिल बनाने के लिए उस पर 5,000 प्रत्येक बिल का
और बिल होता था 6,000, 7,000, उस पे हम 5,000 का डिमांड कर रहे थे that I have stated in my petition also, para 10, page 5. 3 बिल पेंडिंग है इनका, 6,768 रुपए का, 5,077।
ये इंफॉर्मेंट तो है कृष्णा उरांव।
हाँ, कृष्णा। Page 16
एफआईआर तो कृष्णा उरांव का है।
हाँ।
हाँ बट मतलब जो फर्स्ट कंप्लेंट जो है पेज 16 में
पेज 16 में ही
हाँ उस मामले के संबंध में वहाँ से निवेदन को करना है कि मैं तारामुनि नाम अति श्री कृष्णा उरांव
कि लिखा तो हुआ है कृष्णा उरांव का, साइन किसका है?
कृष्णा।
यस,
लेकिन यहाँ जो मैं तारामुनि नाम
तो उससे क्या हम आपको से करेंगे? जिनसे पेमेंट ले ड्राफ्ट केस इज वेरी टेक्निकल। Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that any antecedent?
No.
The petitioner is in custody since 22/12/2025, having no criminal antecedent. He submits that 27/12/25, having no criminal antecedent. He has submitted that, as per the FIR, the husband of one Taramuni Uram, who is and is the
Mate.
just a moment, is the husband of Taramuni Uram, namely Krishna Uram, is the complainant who has lost the FIR, and it is alleged that Taramuni Uram was made in Manrega scheme, and the petitioner has been demanding ₹5,000 for passing the bill. He has submitted that though the petitioner is said to have been apprehended with bribe money, but the bribe money was offered by the husband of Taramuni Uram. He has further submitted that under note, the husband of Taramuni Uram used to approach the petitioner for payment, and since Taramuni Uram was the concerned person and the mate in Manrega, there was no question of any payment to her husband. Yeah.
Yes.
He has further submitted that charge sheet has already been submitted. Charge frame हो गया?
Charge नहीं।
The learned and he submits that he shall cooperate for framing of charge as well. The learned counsel for the state has opposed the prayer. However, the aforesaid submissions made by the petitioner is not in dispute. Considering the aforesaid submissions and the custody of the petitioner and charge sheet having been submitted, the petition is added to be enlarged on.
Serial number 49, BA 2967 of 2026 with serial number 50.
क्राइम का एलिगेशन है और एक मोबाइल में सिम रिकवर, जो विक्टिम नहीं है, कोई इलीगल ट्रांजैक्शन नहीं है, कोई क्रिमिनल इंसिडेंट नहीं है।
One mobile, one SIM, no victim.
No.
पर इन्वेस्टिगेशन इज गोइंग ऑन।
क्या स्टेज है अभी? कब से आपका चार्ज शीट हो गया?
चार्ज शीट नहीं हुआ।
हम आपको बेल नहीं दे सकते।
इसमें नहीं हुआ।
BA number 2967 of 2026.
Liberty did the after filing of charge sheet.
Counsel for the petitioner submits that one mobile and one SIM has been recovered from the possession of the petitioner
इसको विड्रॉ कर लेते हैं।
Counsel for the petitioner seeks permission to withdraw this bail application, and on the ground that charge sheet has not yet been submitted. Permission is accorded. This bail application is dismissed as filed.
Serial 50 BA 3354 of 2026.
One mobile, no victim. Charge sheet हो गया? तब कहाँ से हो? कौन बोले charge sheet? Charge sheet हो गया? बताइए, चार्ज शीट हो गया इनका? कस्टडी कब से है?
कस्टडी है 17/2
तो चार्ज शीट नहीं हुआ होगा।
चार्जशीट नहीं हुआ।
तो इसको 12 तारीख को
नहीं, आप सेम ऑर्डर कर लीजिए। चार्ज शीट होने के बाद आएगा।
वो
चार्ज शीट होने के बाद
नेक्स्ट
आएगा।
कर दे याद
नहीं
है
हो पाएगा।
नेक्स्ट 12 को इसके पहले वाला 12 को रखना है 12 को।
देखिए, एक का विड्रॉ हुआ है ना, नहीं करना। नहीं तो हम रिजेक्ट कर देंगे। अभी चार्ज शीट नहीं हुआ, रिजेक्ट कर दें।
विड्रॉ कर लेते हैं।
सेम ऑर्डर।
Serial number 51 BA 3061 of 2026 with serial number 52.
One mobile, one SIM, no criminal incident, charge sheet has been submitted. एक victim पैरा 868 में आया है 1000 रुपया का. That to a IMEI number और number नहीं है.
One mobile, one SIM, one victim.
1000 rupees. वो भी
No
IMEI.
antecedent.
No antecedent. Custody 11/1.
चार्ज शीट सबमिटेड। क्या बोलना है आपको?
1262 में है लॉर्डशिप की 173 FIR एंड 6715 1262 कॉमन दिया हुआ है।
तो मेरा नहीं है FIR एक भी बोल रहे हैं मेरा FIR नहीं है।
पैरा 62। आपने काउंटर में फाइल किया है? बोल रहे इनका FIR।
कोर्ट का ही डायरी देखिए।
नहीं कोई ऑनलाइन पोर्टल पर है उसका लिस्ट आया है उसमें मेरे खिलाफ में ऑनलाइन पोर्टल पर कंप्लेंट है ये
आप जरा इनको काउंटर फाइल।
Yes.
The learned counsel for the state is directed to file counter affidavit in this case, bringing on record the various criminal cases which is said to have been instituted against the petitioner in different states of the country. ठीक है, जितना भी स्टेट है सबसे कलेक्शन करके फाइल कर दीजिए। बताइए कौन दिन है? 15 तारीख को रख देते
13 तारीख को अदर केसेस
इसी FIR का
यस
पोस्ट ऑन 13। ठीक है, आप पता कर लीजिए। सेकेंड हाफ का वो बैच
जी।
बोलिए।
From daily cows list under heading for partner matters, serial number 1. First appeal 34 of 2025.
That we have noted your arguments. Last year.
submitted before the reference to
Where is the state? Respondent? Respondent कहाँ है? Yes. Argue. Argue your case.
नाम का और जो फर्स्ट जो राजेंद्र नाम है, दोनों में 17/7/20
17
17/7/20 जो मैंने पिटीशन क्वालिफाई
फाइल हुआ ना?
दो केस में दोनों मिला है।
आप बताइए, आपके पास रिकॉर्ड है, आप जो जितना आप बहस करेंगे उतना ही हम जानेंगे ना,
दो केस का दोनों मिला
वो हम नहीं जानेंगे।
है।
सब में है
एक ये एडवोकेट लगता है सब में पिटीशन फाइल किए हैं रेफरेंस के,
तो पैसा उठाने के पहले तो ऑब्जेक्शन फाइल,
लेकिन प्रोटेस्ट रिसीव जो
उससे क्या मतलब है भाई?
अमाउंट रिसीव विद प्रोटेस्ट नहीं।
उससे क्या मतलब है? हाउ डज दैट मेक अ डिफरेंस? दे हैव ऑलरेडी रजिस्टर्ड देयर प्रोटेस्ट। कहाँ लिखा है कि प्रोटेस्ट लिख कर लेना पड़ेगा? तो बस ठीक है। और बताइए क्या बोलना है इसके अलावा?
लेकिन जैसा Actually has also pointed out regarding the judgment is cryptic. Judgment is cryptic. No finding, no reason.
हम इसको वापस रिमांड नहीं करेंगे। नॉट अ केस फॉर रिमांड। एक जगह से दूसरी जगह लोग मूव कर नहीं रहेंगे। आप क्वांटिफिकेशन में मदद करिए, बताइए क्वांटिफिकेशन कैसे होगा? 2013 का एक्ट, 2013 का एक्ट।
लेकिन ये जो सेंटेड है इनका सेंटेड तो
पर एकड़ का इन्होंने तीनों का दिया है, पर एकड़ का रेट हाईएस्ट का, दो हाईएस्ट का एवरेज लेना पड़ेगा, ठीक है? तो एग्जिबिट 1 एंड एग्जिबिट 1/1 एक 24/7/2016, एक 1/6/2018। यही है ना? व्हाट इज द डेट ऑफ एक्विजिशन? सेक्शन 11 20th अगस्त ना? तो इसका एवरेज कितना होगा? 253 and the other is 273,750 per decimal. He has not calculated it per decimal, has he?
नहीं सर, नॉट कैलकुलेटेड पर
कुछ भी नहीं एडॉप्ट कर दिया। How much is the land acquired?
56.4 कीजिए para
Para 2. He has enhanced the compensation, the rate to 1 crore.
Yes.
He has not quantified on individual basis. There should be quantification on individual basis. Isn't it? You just tell us that as per the provision of 2013 Act, half of the two salaries are to be taken into consideration. Half of the number of salaries is to be taken into consideration, whichever is higher. 3 salaries have been produced, so 2 will be taken into consideration to come to average. 1 and 1/1. And consequently, the average would be whatever be the average, we will find it out. लिखा ही जरा average calculated digit.
Average is coming 2,50,580.
So it is coming how much?
2,50,583. Average is.
Average of 3 salaries. Average of 3 salaries नहीं हुआ sir. It is half of the sale is produced. आपके फेवर का बात कर रहे हैं, आपके अगेंस्ट का बात नहीं कर रहे. You just see this section.
B. The average sale price for similar type of land situated in the nearest village or nearest vicinity area. Section 26.
Yes. Explanation 2.
And thereafter we will
You read explanation 2. For determining the average sale price referred to in explanation 1, 1/2 of the total number of sale deeds or the agreements of sale in which the highest sale price has been mentioned shall be taken into account. तो 3 का half कितना हुआ? Yes, Mr. Mehta, you tell me. There are 3 sale deeds which have been produced by you.
I calculate. Just
तीनों का
250.
It will be 26, 2,63,375 per decimal.
Average of three.
average of two sales.
Average of 2 sale deeds.
Of higher
Of higher value.
2 lakhs.
So
that will come to 60. And average of 3.
average of 3 तो नहीं लेना है ना. As per that, average of 2 which has the higher value. So exhibit 1 and exhibit 1 by 1.
That will come to 60.
It will come to 263,375.
263.
आप कैसे अपने लिटिगेंट के अगेंस्ट पे कैलकुलेट करते हैं? अगर हमसे कुछ गलती हो रहा है तो बताइए. गलती नहीं करता हम लोग. Average of 3 sale deeds आप कैसे लिए? How did you take the average of 3? As per the act, it is average of half of the sale deeds produced.
If we will calculate these two jointly, then 273, 750 and 253.
Sir, आपसे पर you argue that average of 3 sale deeds is to be taken into consideration. Am I committing some error when I am saying that average of only 2 sale deeds will be taken into consideration?
That I have explanation 2. For determining the average sale price referred to in explanation 1, 1/2 of the total number of sale deeds or the agreement to sell in which the highest sale price has been mentioned shall be taken into account. Now, 1/2 of the total number of sale deeds. If we will consider 3, then or otherwise because there is no 2.
We will not consider 3 because altogether 3 sale deeds are being produced.
Yes.
We'll take half of the total number of sale deeds. सर हिंदी में समझो. You see, अगर 10 sale deed produce हो which are within the period of 3 years prior to section 11 notification, then half of them which has the highest value will be taken into consideration और उसका एवरेज निकालना. तो 5 सेल डीड में जिसमें मैक्सिमम होगा उसका एवरेज निकाल के कॉम्पनसेशन विल बी. आपके केस में 3 सेल डीड, तो 3 का हाफ 1.5 होता है. तो 1.5 तो नहीं हो सकता ना. वी विल टेक 2. इफ वी टेक 2 इट इज एंड हाईएस्ट वैल्यू लेना. इट विल बी exhibit 1 and 1/1 because exhibit 1/2 is of a lower value.
Yes.
Right? Then we will take exhibit 1 and exhibit 1/1 and then 1 decimal का exhibit 1 is 2.53, उसका है 2.73 exhibit 1/1 and then we calculate these two, 2,53,000 plus 273,750 divided by 2, it comes to 263,370. तो आप जो तीनों का एवरेज ले रहे थे तो आपका तो कम हो जाता ना पैसा।
नहीं, हम इसी में वो पहले तीन
आपको 25 कितना फिगर?
Half of the share did what he gives half of the share half of the
तो ये 0.5 तो नहीं हो सकता ना। देखिए, the learned counsel for the state has submitted that though the petition seeking enhancement of compensation was filed prior to accepting the amount, but at the time of accepting the amount,
there is no protest.
है उसमें भी है, हमको पता है।
एक आदमी का है, हमने नाम बता दिया।
I am having the certified copy of all the payment voucher in which it is mentioned before receiving the amount आपत्ति के साथ भुगतान ले रहा हूँ।
इस केस में नहीं।
तो certified
एक ही केस में है बट कोई
सब में
वाउचर में लिया है, जो मेन वाउचर है। But the records do not reveal that at the time of receiving payment, the protest was mentioned. At this, the learned counsel for the petitioner has submitted that the protest is recorded while receiving the payment, and he has produced certified copies to show that even at the time of receiving the amount, protest was registered. And however, it is not in dispute that at the time of that prior to receiving the amount, the petition seeking enhancement was already filed. The learned counsel for the state has again insisted that since the impugned judgment is a cryptic judgment and ad hoc price has been enhanced, the ad hoc and compensation has been enhanced on ad hoc basis, the matter be remanded. To this, counsel for the petitioner appellants has reiterated that the materials are before this court, and it is not in dispute that prior to receiving compensation, the petition seeking enhancement was already filed. And what is required to be considered is only the 3 sale deeds which have been produced by the appellants before the learned court. As the respondents hearing did not produce any sale deed to substantiate the market value of the acquired land or to justify the compensation paid by them, and the compensation is to be assessed in terms of section 26 of the Act of 2013, read with its explanations. The amount be quantified by this court, and the case be decided on merits. He has given a chart whose details have mentioned, ये चार्ट हमने इसमें कोट किया है, हाँ, whose details have been mentioned in the order dated 23/4/2026, and submits that out of 3, 50% of highest value is to be taken into consideration, and therefore exhibit 1 and 1 by 1 would be the deeds for such consideration, and the average would come to rupees 2,63,375 per decimal. That's all. खाना पड़ेगा फिर. अभी नहीं.
Apart from that, in section 13, what of procedural?
If that is already there,
And
rest में तो कोई dispute ही नहीं है. They have calculated it rightly. सभी तो दिया आपको. The learned counsel submits that apart from the aforesaid amount, the statutory amount which has been included in the award is also required to be recalculated. Right? सभी दिया हुआ, सब every
12% another, that is subsection 3 of section.
सब जितना है हम देखिए. आप आपका सारा आर्गुमेंट सुनने के बाद अब नया कहानी मत सुनाइए.
इसमें ऑलरेडी अवार्ड में सब लिखा हुआ.
Everything is there in that. Okay, reserve. एक हम लोग जजमेंट किए थे, बैच केस एक किए थे, ये इसी पर सेक्शन 13 में पंकज ने किया. बैच केस था, आई थिंक 100 केसेस ये थे ना. 109 नहीं 100 केसेस का बैच था.
हाँ, मिथुन कुमार
नहीं वो तो था 400 केस का.
हाँ,
एक 100 केस का बैच था, ये सेक्शन 13 का. उसमें भी आप कैलकुलेटेड इट इन दिस मैनर.
सप्लीमेंट्री कॉमन जजमेंट का सीरियल नंबर 3 लगाने की
वन सेकंड.
आज का सप्लीमेंट्री सीरियल नंबर 3.
It is arising out of the common judgment.
कॉमन जजमेंट लिमिटेशन है इसमें 113 दिन.
इसमें क्या बोलना है? सेम जजमेंट. पे नंबर 109 of 2026. The learned counsel for the petitioner submits that this petition is barred by limitation by 106 days. An interlocutory application has been filed for condonation of delay. He has submitted that under similar circumstances, the limitation has been condoned with respect to other analogous cases, which are listed for today for as partnered matters at serial number 1 in the main cause list.
इनका नाम पैरा 2 में इंक्लूड जजमेंट.
The learned counsel further state does not dispute the aforesaid submissions. Being satisfied with the cause shown, the delay in filing the appeal is hereby condoned. The records are already available, and consequently, this appeal has also been heard on merits, and the order is reserved. Along with the analogous cases, ये common order करते हैं. एक हाँ supplementary.
From supplementary cause list under heading for order serial number 1, WCL 7038 of 2017.
May seek Lord's leave to allot go online into DC and assistant house.
This is posted for IA.
Yes, we have complied with the last order, and the
What is the
Advocate
second
of record has also filed the written submission with judgments and relevant portions of the Act. Right.
Today we are for your amendment, IA.
Yes. Now, Milords, you Milords will see this IA was filed, Milords. Milords.
You have received the copy of the written submission? Copy मिल गया आपको? You have received the copy? Yes, IA has been filed. What
Yes.
what amendment are you seeking?
Yes, I am seeking the amendment, Milords, to challenge the second approval on the change of the name of respondent number 5.
No, this amendment, there is one more amendment, 3782 of 26.
Yes.
This is with regard to party position only.
I'm sorry, Milords. Milords has which ID number? I'm sorry.
No, this case has only come up for this because we cannot hear it prior to vacation. This IA number 3782 of 26 in WPC number 3209 of 24.
I'm sorry, Milords. I am not appearing in that case. My case is WPC 703.
Yes, please hold on. Yes.
Amendment in the memo of the party of the
No, you can't change the memo like this. You have filed your case in individual capacity.
No, it is not filed for that individual capacity. It is filed by the union.
No, it is not filed by the union. How do we permit this amendment?
प्रकाश कुमार तीन लोग हैं प्रकाश कुमार अभी ये जनरल सेक्रेटरी के हैसियत से फाइल कर रहे हैं एक है
नहीं देखिए फर्क है ना when you describe yourself as Mr. Prakash Kumar, right, then there is no seal of the union required, correct? अब आप इसको चेंज करके आप यूनियन पहले लगाना चाहते हैं और मिस्टर प्रकाश कुमार बाद में लगाना चाहते हैं, to project that the case has been filed by the union. How do we allow this? How do we allow this? Tell me. We will not allow this. You have to decide. जैसे कंपनी एक डायरेक्टर फाइल कर दिया केस, डायरेक्टर मिस्टर सो एंड सो, डायरेक्टर ऑफ सो एंड सो कंपनी. It is totally different from the company represented through the director. It is not one and the same thing. I will not allow this amendment. ऐसा nomenclature नहीं चाहिए सर. आपका जो है उसी में आपको चलना है. Counsel for the petitioner seeks permission to withdraw this IA number 3872 of 2026 in WPC number 3209 of 2024. Accordingly, this interlocutory application is dismissed as withdrawn.
Regarding the first matter, WPS 703A, there are two IAs.
Yeah, yes.
Yes. Please.
क्या अमेंडमेंट कर रहे आइए अमेंडमेंट
हाँ दे दीजिए जैसे
Lord, it might not permit me to find a continuing compilation.
इसका आइए है
हाँ इसमें आइए में है सारा चीज लगा हुआ सीक्वेंस वाइज. At line page 571.
571.
First idea, running page 571.
On behalf of respondent number 8, 571, IE number
580.
580.
Yes. May I submit because my learned friend, I'm obliged to my learned friend. because-
580 is
Yes.
restoration application.
Yes. Because this is regarding my IA 7574.
It is not matching. Whatever you have given is not matching. Which page number is this? ये आपका इसमें मैच नहीं कर रहा आपने इस not
The
matching.
convenient implication.
हाँ, it is not matching. Which page number should I see? Which page number should I see in this compilation?
$567 is the IA, of which is in issue was 567 of the convenience compilation.
567 is a part of the order passed by the Supreme Court. It is not matching.
I'm sorry, Millers.
हर डेट में आप लोग ऐसे कंफ्यूजन क्रिएट करते हैं. I
No,
can't
no,
do
no.
anything.
I'm sorry. If Millers will see the Millers may keep that convenience compilation aside. My learned friend will correct the page numbers.
उनको वापस कर
Millers.
दीजिए.
Yes. But however, on the record, Millers,
Yes.
we are concerned here regarding IA number 7574 of 2018.
7574.
Of 2018.
Yeah, I did the details of it. No, I can't get it. I'm unable to find it out.
If I can request my learned friend, he will.
You see, we don't have time to waste like this. इतना confusion आप लोग करते हैं कुछ पता ही नहीं है. 7574.
Yes, of 2018. I'm obliged.
Yes. What is it for?
Hello. The prayer in this was for issuance of the writ. It was filed. Now the prayer was that, my lords, at page running of this application is at page 10. 10 if it is there. At paragraph 23. It is therefore prayed that your lordship may graciously admit this application and after hearing the parties may further be pleased to allow the interlocutory application to permit the petitioner to amend the writ petition in terms of 18 and 19 of this application. Now 18 and 19 are at page 9, para 18. I'll read that under the circumstances, petitioner prays for amending the writ petition by adding following prayer just below the prayer portion at para 1, sub-para C, for issuance of a writ in the nature of certiorari for quashing the memo number so and so of Shram 1519 Ranchi dated 31st July 2018, issued by Joint Labour Commissioner cum Registrar Trade Union Jharkhand Ranchi, whereby and whereunder approval has been given to the amendment in the bylaws of TML Drivelines Workers Union.
Yes, what is your objection to this relief? You will file counter.
To the IA.
You have not filed counter so far.
Fine.
So what is your objection?
I have saying that
इनका reply निकाल. When did you file your reply? When did you file your reply? When did you file your reply? 15th of this month.
15th of
Respondent number 8 has filed reply. You are respondent number 8. दोनों आइए का सेम रिप्लाई फाइल किया, वन रिप्लाई
दोनों अलग
नहीं
एक तरफ फाइल है, फाइल तरफ से
there are common reply to two IAs. One is IA number 1361 of 17 and other is IA number 7574 of 17 and IA number 11397 of 25. ये तीन IA का common reply है.
1139 is simply for restoration of this reply. 1139 is not
Okay, fine. What about 1361?
1361.
Yes.
1361.
1361 IA.
Since my reply is very simple, that the petitioner is a deregistered trade union, and the deregistered trade union cannot maintain the rate itself. When the rate itself is not maintainable, there is the question of maintainability of the IA.
That deregistered trade union, that order has been stayed
Well, they kindly see.
by Patna High Court.
I have my attendance the documents in kindly see.
No, we will see the document. But that particular order has been stayed or not?
Well, that order has been stayed, but my lord may kindly appreciate against that deregistration. They have moved before this one. There was direction to move before the registrar. They moved before the registrar, but they filed LP also.
That we will hear all
in
that.
that LP also, my lord, which kindly appreciate. In that LP also, the direction was given to the registrar to decide their registration. The registrar has decided the registration, their application. My lord, I have brought on record
You
the.
see, the main document by which their registration was cancelled
My lord.
on account of non-filing or non-adhering to certain requirements, right? That has been stated. And everything else has happened pursuant to the cancellation of registration at Patna.
Against that cancellation order, my lord, they have moved up to Supreme
May
Court.
have moved,
And,
but there is you go and move Patna High Court and get that order recalled because that order is binding. Are you a party in Patna?
No.
You are not a party in Patna.
The Tata Motors has moved before the Patna High Court, and they have filed a petition for vacation of their state.
Okay, very good. That's fine. But as on once it is vacated, we will see what is to be done. But as on date, this IA has to be allowed because that is a whole basis. आपको जो बोलना है आप अपना करते
Well,
हो.
because issue I will do was simple. The issue with respect to integrity of the point.
We will see that. We are on the IA. We will decide everything. We will decide everything. There is no problem about it. ये कैसे अभी कैसे बन सकता है? ये अभी नहीं.
Maybe the registrar, Patna, Jharkhand registrar has also called them. The direction was given by
We
the
will see.
registrar.
You see they will file an amended writ petition. You file a consolidated reply to the amended writ petition. Simple. They will file an amended writ petition. You file a reply to the amended. Whatever you have to say, you say over there, maintainability or whatever it is. Right?
So this, I have also got on report my lord's judgment passed with the Supreme Court also with respect to this. Because this writ has been filed concerning this matter.
We will see that. We will see everything. You see, so far as this IA is concerned, IA number 1361, that cannot be allowed. That we are not going to allow that.
Milords, right now I am not pressing it. Milords, may
IA
keep
number
it pending.
136, no, I will not keep it pending. I will not keep it pending as long as the interlocutory applications are pending before this court. We will not be able to decide the case. So,
Why I am saying
because this particular relief, no, we are not going to give you any relief.
Milords, why I am saying this, if Milords could in the that intelligence that this is part and parcel of the
No,
final.
it is not the part and parcel. You are asking us to restrain them from offering membership. We are not going to take into consideration on that. Everything will depend upon. You see, if you ultimately win and there are large number of members who are inducted, you have your all remedies about it. This idea I am not using.
Correct, Milos. So, Milos, if Milos will just say that currently it is not being pressed at this stage.
IA number 1361 of 2018, the Learned Counsel for the petitioner submits that this interlocutory application is not being pressed at this stage. Considering the submission, this IA is dismissed as not pressed.
Yes. Milos, with liberty to raise this point.
I will not say you have prayed at this stage. I have recorded.
Very good.
So far,
Very good.
with not just take this IA. IA number 7574 of 2018. This interlocutory application has been filed seeking amendment primarily in the prayer portion of the writ petition, apparently on account of certain subsequent developments. As mentioned therein, the petitioner is seeking to incorporate the relief as mentioned in paragraph 18 and 19 of the interlocutory application, which is quoted as under. The Learned Counsel for the respondents has opposed the prayer and has submitted that the writ petition itself is not maintainable as the registration of the trade union itself was cancelled at Patna, and it was de-recognized. To this, the counsel for the petitioner has submitted that the order of cancellation of the order of cancellation filed at passed at Patna is subject matter of LPA number.
WP Milos.
In subject matter of WP.
Yes.
WP.
I'll just get the number. WPC number 5952.
5952.
Of 2023.
Of 2023, filed at Patna.
At Patna High Court.
Filed at Patna High Court, wherein the order of cancellation itself has been stayed. To this, counsel for the respondents has submitted that they have moved an application before Honorable Patna High Court for vacating the order of stay. After hearing the Learned Counsel for the parties and considering the aforesaid facts and circumstances and the subsequent development which is sought to be introduced through interlocutory application, this court is of the view the IA number 7574 of 2018 seeking amendment of the writ petition is hereby allowed. It will certainly be open to the respondents to take all points available which may arise out of which may arise in this writ proceedings, including the points of maintainability. The counsel for the petitioner is directed to file an amended writ petition within 10 days, within 2 weeks from today. The respondents shall file their reply counter affidavit to the amended writ petition, and 2 weeks thereafter, rejoinder if any within further 2 weeks. बताइए 6 हफ्ता कब खत्म हो रहा है?
It's over by mid of June, second week.
Third week June में लग जाते हैं? Third week June Thursday. Third week June Thursday?
Yes.
Just a minute.
If Melons will keep it as part heard
क्या ही पाठ्यक्रम करेंगे आप लोग का तो आइए ही नहीं खत्म होगा.
And I'm so sorry, plus all IAs are over currently. So if Milos could keep it as part third, because we have also filed written
See, last
submission.
week June may not be possible. I'll post it on 1st of July. On 1st July, right? So far as IA number 1397 of 2025 is concerned, the learned councils have submitted that it has become infructuous, right?
Yes.
IA number 11397 of 25 is treated as infructuous. अब कोई IA नहीं pending है ना?
No, I.
This can be posted for final disposal. Return submission pursuant to order of deduction की return submission.
आप देखिए आपका जो ये फाइल का स्थिति है ना, ऐसे में आप डिसाइड नहीं करते. इसीलिए आपको वो अमेंडेड रिट पिटीशन फाइल करने बोले, आप सारा कुछ इनकॉर्पोरेट करके एक
छोटा बना लें.
एक आइए और पेंडिंग है 11380 in interlocutory application on behalf of respondent number 8.
Then that is for respondent number 8.
Who is for respondent number 8? IA number 11380 of 2017 is dismissed as not pressed. Okay? इसमें ना जितना भी आइए सब अलग कर देना है, इसमें सबका रिटन सबमिशंस आया हुआ है, तो सारे रिटन सबमिशंस को अलग कर देना है, और ये जितना भी रिकॉर्ड है इसको स्पैडी करना है, पूरा रिकॉर्ड एकदम डेट वाइज जितना भी पिटीशंस इसमें आया हुआ है डेट वाइज आइए हो सप्लीमेंट्री हो डेट वाइज अरेंज करके पूरा स्पैडी बाइंडिंग भेज देंगे और इसका कंटिन्यूअस नंबरिंग करेंगे. ठीक है? हम तो अपनी तैयारी करेंगे ना, आप लोग का तो देख रहे हैं कुछ भी मैचिंग नहीं होगी. हम जानते हैं ना उस दिन भी आपके सीनियर को चीजें पता नहीं होगी, हम देख रहे हैं आप लोग का सीनियर के साथ कोई कम्युनिकेशन ही नहीं है. आप लोग कोई सिटिंग नहीं करते हैं केस होने के पहले. आई कैन मेक आउट आप लोग केस होने के पहले कोई सिटिंग नहीं करते. आप लोग सिटिंग किए केस टेकअप करने के पहले? नहीं किए. आई कैन मेक आउट आप लोग का कोई कॉन्फ्रेंस नहीं हुआ है, कोई मीटिंग नहीं हुआ है, कुछ नहीं हुआ है, बस यहाँ पे खड़े हो गए. इतना लिबरल कोर्ट है ना आप लोग को, इसीलिए लगता है कुछ भी बोल के चले. चलिए सर ऐसा ही.
अगर कल रात में रहता तो वीसी से नहीं आते, हम लोग तो सब फिजिकली रहते हैं.
May I make a request?
Yes.
May I additionally submit on May a soft copy of the written submission and convenience compilation works, if that is.
You want to submit?
Yes. On mail, a soft copy, if that is possible.
No, that is first you complete your pleadings. I just do not know. Whatever you want to submit, you do it. But nothing should be beyond the record. This is first thing. Secondly, there should not be any mismatch.
Of course, because I'll
there should not be any mismatch. First, you file your amended writ petition.
I'll personally take care of it. I'm so sorry.
Thank you.
Much of
लिटिगेंट को बोलिए दिल्ली जाने का फ्लाइट का टिकट दे, वहाँ जाके बैठा करिए, समझा करिए.
जो बोले सब सुनिए.
आप समझ रहे हैं ना, मतलब ऐसे नहीं होता है. हमको देख के पता लग जाता है आप लोग का कोई मीटिंग नहीं.
नहीं, हम तो बोले कि कल रात अगर रहता तो हम लोग फिजिकली यहाँ प्रेजेंट रहते हैं.
अब वो तो हमेशा नहीं आ सकते हैं. ऑनलाइन वी आर नो इशू, बट यू हैव टू गो एंड ब्रीफ इन प्रॉपर्ली. एंड यू हैव अ टीम ऑफ एडवोकेट्स. एक वहाँ पर उनको असिस्ट करने के लिए भी होना चाहिए. नहीं है ना कोई?
हम सुबह मेल में भी भेजे हैं.
Under heading from Delhi Council list under heading for orders serial number 8 first appeal 153 of 2024.
This is issued on the last date of action. Respondent number 1 to 30, apart from respondent number 10, 1 to 10 has been delivered. Respondent number 10 has died, for which we will file the new application in
further, Your Lordship, in the IA 3545 of 25, Your Lordship directed us to make the correction with the red ink, but inadvertently we made it. That we will do it.
When did I ask you to do it?
This is order dated 22/2026.
बीस दो.
Yes. On the same case, we did it, but with the
FA number 153 of 2024, the learned counsel for the petitioner submits that due to inadvertence, the necessary correction in terms of order dated 28 February 2026 could not be carried out. At his request, he is permitted to do the needful during the course of the day. Next, it has been reported that respondent number 10 has expired. Kab?
the date we will contact. But we have
However, the counsel for the petition is not aware of the date of death of respondent. He seeks adjournment. Post on 11th June.
Serial number 9, first appeal 12515 of 2025.
Yes. For you, for the state, they are seeking exemption from deposit of court fees of rupees 21,300. What do you have to say? IA number 1765 of 2026. The learned counsel for the state prays for time to respond to the interlocutory application seeking exemption from deposit of court fees. Post on 11th of June. The reply should be filed by 8th of June. The reply should be filed by 15th of May. Rejoinder depending by 9th of June.
Serial number 10, first appeal 13259 of 2025.
My lord, in this case, a limitation petition has been filed, IA number 1002226, that has wrongly been filed. So I just want to withdraw that one. There is no delay, that has
IA number
filed. Second
100
one
of
is
2026, counsel for the petitioner seeks to
Another-
submits that he does not want to press this interlocutory application. Accordingly, this application is dismissed as not pressed. Yes, further.
Another IA is 100/2026, that's related with the deficient court fee. In this regard, my lord, just I have to point out section 149 of CPC, that is a discretionary power this honorable court, that is power to make up deficiency of court fee, where the whole or any part of any fee prescribed for any document by the law for the time being in force relating to court fees has not been paid, the court may in its discretion at any stage allow the person by whom such fee is payable
You
to
see,
pay the whole or part.
Just a moment. Just
Whole
a
or
moment.
part is the case may be.
No, no,
of
you
such
just hold on for a moment.
जी
आपको जो अवार्ड मिला है वो अमाउंट आपने उठाया है कि नहीं उठाया?
उठा लिया।
तो आप पेमेंट करिए. You are not a person who is not who
बहुत
is deprived of money.
ज़्यादा पैसा है, that is 60,664।
उससे क्या
वो
होगा?
4 लाख ही केवल पैसा मिला, उसमें 3,000 तो उसका रेट दिया है, whereas the market rate was more than 70,000। तो उसमें जो रेसिडेंशियल वैल्यू था वो भी नहीं दिया, एग्रीकल्चर रेट दिया 3,500 समथिंग। That comes to 4
आपका
लाख।
डेफिसिट कोर्ट फीस कितना है?
कोर्ट फी है 60,660।
डेफिसिट कितना है? How much?
60,664. That is in stamp reporting. 60,664. That advertorial court fee is there. Point out here that
आप हमको इतना बताइए.
इसमें मेरा
Just a moment.
है, चार-
Just a moment, please hold on.
4 लाख
You just tell me, suppose you lose the case.
No,
Suppose you lose the
during-
case.
During the proceeding of this case, not after disposal of this case, during the proceeding of this case, that ad valorem court fee will be paid. I just have.
Ad valorem court fees will be paid during the pendency of this case.
Pendency of
कितना टाइम आपको चाहिए बताइए? कोर्ट फीस पेमेंट करने के लिए, उसके बाद ही आपका केस सुनेंगे, इसके पहले नहीं सुनेंगे. How much time do you need to pay the court fees?
This one is just talk with the client at least 4 weeks time.
4 weeks time.
Why just withdraw this one? 4 weeks time may be lost.
IA number
ID number
1004 of 2026. The learned
I want to
counsel.
withdraw this one.
The learned counsel for the petition appellant seeks permission to withdraw this interlocutory application. Accordingly, this IA is dismissed as withdrawn. The counsel for the appellant pays for and is granted 4 weeks time
6 weeks.
and is granted time till 30th of June.
6 weeks.
30 जून तक हो जाएगा ना 6 हफ्ता आपका.
Now court just talk to the client. Because the amount is 60,000.
30th of June और ज़्यादा चाहिए अगले साल तक.
नहीं.
और 2-3 साल.
देना हो गया तो they will pay otherwise not.
30th of June 2026 to pay the deficit court fees promptly. If this order is complied within time, post this case under appropriate heading on 9th of July. और तो कोई डिफेक्ट नहीं है.
नहीं बस.
Serial number 11. FA 14922 of 2025.
was paying for a week time and you're writing it only for ignoring.
You said on the last date that defect number 67 and 68 have been removed.
Minutes, no, I did not say much. That is required because it is a.
Oh, you did not appear.
Yes, Malas. It is a decree, Malas. It is required to be considered to be.
Filing number FA 14922 of 2025. Time till 30th June 26 is granted to the appellant to either to remove the surviving defects or to file appropriate interlocutory application in connection with one or the other defect. Right. If this order is complied, post this case on 9th of July.
Yes. I'll be filing it within a week. There's some urgency.
Just a moment. वो जो 30 जून का डेट दिए थे मैडम, उसको कम करके कर दीजिए. कब तक करेंगे?
एक वीक के अंदर कल परसों मंडे फाइल.
ओके. बाय 7th कर देंगे. बाय 7th प्रेम्पटरी ऑर्डर है, ध्यान
हाँ
दीजिए.
ठीक.
पोस्ट ऑन 14th.
The heading for order, serial number 12. First appeal 148 of 2024.
Notice was issued to respondent number 3 to respondent number 7. However, those notices were undelivered and unserved as respondent number 3 has left the premises. Respondent number 4, the care of name is incorrect, so they denied to take it. And respondent number 5 to respondent number 7, they said that no such addressee resides in that same address. So just
FA number 148 of 2024.
issue fresh notices.
कौन से एड्रेस? Which address?
This address we have got it present and fresh.
You have got? The learned counsel for the appellant submits that notices were issued to respond number 3 to 7, but the same has remained unserved on account of want of proper address or the addressee was not found at the given address. Time till How much time do you need? Time till 13th of May is granted to the applicant to take fresh step for service of notice upon respondent number 3 to 7 at their present and correct address through speed post for print. It is पिछली बार भी यही हुआ था at the present and correct address.
So we have served this notices, but subsequently it remains unserved.
You have served the notices at the same address which is given in the memo of appeal.
But in Lordship, now we have got the new addresses, Your Lordship. The
So
present
on the last date, on 13th of November, what did you do? There was an order that you will either or at present and correct address.
Yes, Lordship, we served those notices, but subsequently, again it showed that it was undelivered, Your Lordship. To respondent number 3 to respondent.
Did you send at an address which is different from the memo of appeal?
Yes, Lordship, I have sent that.
The same address.
Lordship, as far as what instructions I have, that we have, now we are having the new and present addresses.
Let me just see what new and present address do you have. It's the same address.
Lordship, as far as what instructions I have got.
No, your instructions are not correct.
Seeking new instructions, Your Lordship.
Surendranath Roy, such and such, resident of Lindsay Club Road, Hirapur, POPS, Dhanbad district, Dhanbad, right? And the address which is mentioned and which has returned back, Surendranath Roy, son of such and such, at present resident of Lindsay Club Road, Hirapur, POPS, Dhanbad district, Dhanbad. This notice has returned back.
Then it might be some other addresses, Your Lordship.
Sorry?
It might be some other address, Your Lordship.
So,
So
this is not the correct address.
that was,
This is not the present and correct address. Same address which has returned.
that is
Same
what
address.
I have submitted, that is wrong, Your Lordship, that slip of addresses, Your Lordship.
Yes.
So I have to.
That is not the present and correct
To
address.
get new addresses, Your Lordship. This was notice.
वो प्रेम के ऑर्डर से बचने के लिए सब कहानी की नो मत सुनाइए आपके सीनियर कौन है तो वही ये वो वहीं पे ये सब कहानी चल रही है वो प्रेम के ऑर्डर से बचने के लिए सेम एड्रेस पे नोटिस भेजते हैं दिस इज व्हाट यू आर डूइंग The learned counsel for the appellant submits that notices were issued pursuant to the order dated 13th of November 2025, but the same could not be served on account of wrong/incomplete address. He prays for adjournment to take appropriate steps at the present and correct address upon respondent number 327. Time till 30th of October 26 is granted to the appellant to take fresh steps for service of notice upon respondent number 3 to 7 at the present and current address through speed post or to file appropriate petition seeking substituted service of notice, failing which this appeal shall stand dismissed against the aforesaid respondents without any further reference to the bench. Office to track speed post delivery. If filed. Post on 3rd of December. We are not interested in this.
Serial number 30, FA 222 of 2024.
Complaints of order dated 14/11/2025 for substituted service of notice upon respondent number 12. You are directed to publish the said notice in newspaper.
You have done it?
Yes.
Where is the newspaper? No, you have to file the original paper. It becomes a part of the record. एक पेपर कटिंग नहीं चलेगा आपके में. No. You have to file the original newspaper. FA number 222 of 2024. The learned counsel for the appellant has submitted that a photocopy of the newspaper publication has been filed. He is directed to file the original newspaper. फाइल करिए और कटिंग मत फाइल करिएगा, कटिंग नहीं चलेगा. You have to file the entire कम से कम उसका पेज पूरा जिसमें पूरा ऊपर डेट वेट रहता है and then you just fold it. How much time do you need? Post on next Thursday.
Serial number 14, FA 3 of 2025.
Fresh notices were issued to respondent number 9, 27 and 93. For 9 and 27 has been personally served, and for respondent number 93, there are two police report has come that there are two people by the same name and both have refused to accept.
In your notice, their father's name is not mentioned. अब क्या करें? What should I do? Original suit, you are the plaintiff or the defendant? You are the plaintiff. You have not mentioned the father of the.
Yet on the record also, plaintiff told me, the petitioner told me that he is some fake person. He's not there.
उसी के ग्राउंड पर ये केस को रिलेटेड हो गया, वो आदमी काहे नहीं.
Sorry?
जो आदमी नोटिस जा रहा वो आदमी कभी काहे नहीं.
ट्रायल कोर्ट में भी नहीं आते हैं बोलते.
That's what all the respondents have discussed.
ट्रायल कोर्ट का रिस्पोंडेंट 53 में.
की तरफ से कौन है? 92? What about other respondents? 92 accept that they have appeared?
No, they don't. Only respondent number 1, 2 and 53 are appeared.
And rest, notice is accepted as valid?
That's all, except 93. Everyone has been
क्या बोल रहे हैं?
उसके बेसिस पे जमीन जो क्लेम कर रहे हैं टाइटल, वो प्रायर टू इंस्टीट्यूशन कभी लाइव रहा ही नहीं है. सर्टिफिकेशन उसका एविडेंस वहाँ आया ही नहीं और वो रिकमेंड से उसका क्रॉस एविडेंस नहीं हुआ. इसलिए मेरिट का चीज़ें बात होगी कि वो आदमी के बेसिस को फर्स्ट डॉक्यूमेंट बना कर
I am supporting the petitioner indirectly because I am also the co-sayer of that report.
You are the contesting respondent. Are you the contesting respondent?
साधु के बच्चे को घर आए थे उसके बाद माँ का डेथ के बाद डेट ऑफ बर्थ बच्चा को दिखा रहा है, ऐसा इसमें जो बच्चे जिस पर क्लेम कर रहा है डॉक्यूमेंट पेरेंटल प्रॉपर्टी माँ का ऑलरेडी डेथ हुआ उसके बाद
आप इसको सब्स्टिट्यूटेड सर्विस देंगे। Go for substituted service through newspaper publication.
No person.
कैसे एक्सेप्ट करें? दो आदमी का सेम नाम कैसे एक्सेप्ट करें? नहीं तो फिर बाद में आपको एग्जीक्यूशन में दिमाग खराब हो जाएगा। The learned counsel for the applicant submits that respondent number 93 could not be served, although two men of the same name were found at the given address. But since the father's name was not mentioned, none of them accepted the notice. He submits that right from beginning, the father's name of the said respondent, who was defendant number? Defendant number. Who was the defendant in the suit was not disclosed.
81.
He was defendant number 81 in the suit, and the proceeding was ex parte against him. Ex parte था? Ex parte था? कहाँ से बोल रहे हैं? Proceeding is ex parte against defendant number कहाँ से पता चलेगा? It was ex parte. From where will I get this? Yes. कहाँ से बोल दिया? Ex parte. From where did you say that the proceeding is ex parte against defendant number 81? From where did you say that the proceeding was ex parte against defendant number 81? इतना साइलेंस से कैसे होगा? ऐसे ही हवा में कुछ भी बोल देते बिना देखे। कुछ तो बताएंगे ना।
ये इंटायर ओनरशिप देखने से कहाँ से स्कूल को सब कंप्लीट होगा उसके बाद में मिल जाएगा दिल्ली को ऐसे ऑर्डर इनके पास इंटायर ओनरशिप भी नहीं है कि कब वो
तो बोलने का क्या जरूरत है?
नहीं बोलना चाहिए सबमिशन करना
कौन है आपके सीनियर? या आप ही को करना? Sir? Who is your father? The learned counsel has submitted that the respondent number 81, the defendant number 81 did not file his written statement before the court. However, he is not sure as to whether the proceeding was set ex parte against defendant number 81. Submits that appropriate steps will be taken in the matter. Record इसका आया है क्या? At his grade, the matter is directed to be listed on June 11th. रिकॉर्ड आया अपने से देखिए, मेरा काम है आपका रिकॉर्ड देखना. You check it.
Serial number 15, FA 61 of 2025.
Next week the they have totally take the
Counsel for the appellant seeks adjournment. 11th June.
Serial number 60, FA 80 of 2025.
Notice upon respond number 1 is accepted as validly served. Respondent number 5 has been reported dead. Respondent number 2 to 4 have already appeared. Trial tape record has not been received. Office is directed to send express reminder. Record में है ना इसमें? Post on 11th of June.
Serial number 70, FA 97 of 2025.
नहीं 11 जून मत करिए इसको और थोड़ा लंबा दे दीजिए. 10th of September. तब तक you are there? ये कौन सा?
70.
उसके पहले वाला उसका डेट चेंज करो 10th of September. क्योंकि तब तक तो अगर सब्स्टिट्यूशन होगा तो होगा, नहीं तो प्रोसीडिंग अवेट कर जाएगा. Yes, please.
Notices are issued to respondent number 1 to 51, to respondent number 4, 11, 28, and 33 to 51 has been delivered. To respondent number 9, 22 to 27, item is on the way as per office note. And we have sent again speed post to respondent number 1 to 3, 5 to 8, 12 to 21, and 29 to 32, which is still undelivered.
Council for the appellant is present. As per office note, notice upon respondent number 4, 11, 28, and 33 to 51 has been delivered. The notice is accepted as validly served.
For respondent 40.
Respondent number
40. 40.
40. The respondents are all from state of Jharkhand, same locality.
Some of them will have the same familiars.
Let notice be that the counsel for the appellant is directed to take fresh steps for service of notice upon the remaining respondents who have not appeared through ordinary process. वो अपने से आ जाएगा service report. For which requisites be filed by 12th June. 12th June. 12th June. Close this case on 30th July.
Serial number 18, first appeal 100 of 2025.
Mrs. Devi Su, please.
Sorry?
Mrs. Devi Su, please. On the limits. One is there, 205.
कितना डिले है?
41.
आईए नंबर
2058.
2058 of 2025 has been filed seeking condonation of delay of 41 days. Issue notice on the interlocutory application for which requisites be to the respondents for which requisites be filed by 12th of June. Through ordinary process as well as speed post.
Serial number 90,
Just a moment. Post on 30th of July.
Serial number 90, first appeal 145 of 2025.
Lordship, there are two cases of 19 and 20. 19 is the mandatory regarding and 20 is the land acquisition. So I think 20 maybe first. It will be better, I think. Whatever the.
And one is the
One is the-
mysterious appeal.
Both are the first appeal.
Both are first appeal.
Yes, both are the first appeal.
Arising out of land acquisition.
Land acquisition, same land acquisition. One pertinent to the mango tree, 8 mango tree for the same land. So 20 will be hard.
Appellants are the same.
Same.
तो उसके लिए मैंगो ट्री के लिए अलग किए हैं.
हाँ अलग.
और लैंड के लिए अलग किए.
अलग ही पेड़ नीचे कोर्ट से केस आया है उसी हिसाब से.
दोनों अलग अलग बिकते हैं.
अलग अलग.
पेड़ के लिए अलग और जमीन के लिए अलग.
20 देख लिया जाएगा.
कौन सा करना? जमीन वाला पहले करना.
जमीन वाला.
कौन सा?
20. मेरा एक जो कंसर्न है.
ये क्या स्टेज में है केस? फाइनल हियरिंग के लिए है. What is the stage of the case? Orders.
जी.
Why is it listed for orders?
Earlier I already allow for the limitation.
नहीं.
Notice already issued.
7 days delay.
Yes. Both petition are.
Okay. FA number 146 of 2025. As per office note, notice issued to the respondents for condonation of delay in IA number 5703 of 25 has been served. But nobody has entered the grievance. Counsel for Counsel for the appellant has submitted that there is delay of only 7 days in filing the appeal. Considering the submissions, I am satisfied with the cause shown. IA number 5703 of 25 seeking condonation of delay is hereby allowed.
Similarly 19 also I.
Admit call for records from the concerned court. Issue fresh notice आपको करना पड़ेगा. Issue notice to the respondents for which requisite under ordinary process and speed post be filed by 13th May 26-23. If this order is complied, pose this case under appropriate heading on 25th of June. इसमें भी सेम है.
Same. Delays maybe.
इसमें delay है सर 10 days. Yes, who is there? Delay इसमें 10 days है. आगे है 5704. ठीक है? Same order, a same date. With है ये. Already with है.
अलग अलग.
Okay. Counsel for the appellant has submitted that these two cases be tagged as they arise out of land acquisition of the same land. One is with respect to land and other is with respect to trees over the land. Let these cases be tagged. Admit करके इसमें भी notice करना है. Call for records from the concerned court. Communicate through fax.
May pray one because in IA already served the notice.
वही ना, यही तो दिक्कत है. अब 7 दिन का डिले से फाइल करेंगे तो यही सब होगा. स्टेट को भी जाएगा. डीसी है इसमें.
हाँ yes.
हाँ तो उनको भी जाएगा नोटिस. सबको नोटिस किया.
मचा.
Serial number 21, FA 164 of 2025.
Last opinion notices were directed to issue the respondent number 1 to 5. It has been validly served. Respondent number 1 has appeared, but 2 to 5 has not appeared.
It was notice on the after admission.
Yes, Raj, after admission.
As per office note, notice upon respondent number 2 to 5 has been served. Respondent number 1 has appeared. क्या है ये?
They filed a suit saying that they are the president, secretary, and treasurer of one Jal Seva Sadan, and so the school management of the school, which is run by the Jal Seva Sadan, that should be handed over to them, and that decree has been passed.
You are the defendant.
We were the defendants.
When do you want?
Any day, we are ready for the hearing.
Post this case, बाकी synopsis बना देंगे?
Yes, sir. I am within 2 days.
Post this case for final disposal on 30th July. In the meantime, the parties to file short synopsis of their arguments with supporting documents, with supporting judgments.
Serial number 22, FA 218 of 2025.
Yes, please. Who is appearing?
Serial number 22, first appeal 218 of 2025.
Issue notice in IA number 16006 of 25. To the respondents for which requisites under speed post be filed by May 20. Since the counsel for the appellant is absent, office is directed to forward a soft copy of this order to the counsel to ensure compliance. Office to tax speed post delivery post this case on 18th